Standing by for our next very special guest, and I tell you who is coming up next as you're inside of the Africa Forum. This is Running Africa. I'm going to be speaking with Karen N. Wilson Robinson, an experienced litigator who honed her skills at several big law firms before transitioning to private practice. Her practice is focused on trademark prosecution and litigation, patent or patent prosecution and litigation, intellectual property, counseling, copyrights, entertainment, and residential real estate. She is a member of the New York and New Jersey Bar, the Eastern and Southern Districts of New York and District of New Jersey, and licensed to practice before the United States Patent and Trademark Office and in Jamaica as well. Karen has a Bachelor of Science degree in biology from St. Francis College and a JD from Pennsylvania State University, Dickinson School of Law. She is a member of the New York Bar Association and sits on the Patents Committee, where she teaches patent litigation to law clerks for several judges throughout the United States. She is a vice chair of Team Jamaica Bickle, Inc., president of the Immaculate Conception High School Alumni Association, New York chapter, and sits on the board of the Dominic Alessandro James Foundation in Jamaica. You may have heard the news, and I'm happy that Karen is joining us this morning to help us to understand it, that of the case against Meta and YouTube in the United States, in California to be exact, and the jury finding Meta and YouTube guilty or liable, if you will, I think there is a $6 million or $3 million damages. Not quite sure if the punitive damages are. Yes, I think so. But anyway, Karen is going to bring us up to date. Floodgates of litigation is what they say are going to happen from now. We'll see if that is true. But long and short of it is this. A Los Angeles jury found Meta Platforms and Alphabet Inc. via YouTube legally liable in a landmark civil trial on social media addiction. The jury awarded $6 million in damages to the plaintiff. And a lot of the conversations we're hearing is that this is a precedent-setting case. We want to talk about that because this is a civil case, so the extent to which it's precedent-setting, we'll hear from Karen. It is the first of its kind to hold platforms responsible for addictive design and mental harm. What does this mean? We're joined by my very special guest, Karen N. Wilson Robinson. Hi, Karen. I'm not seeing her, but I guess she's there. You with us, Karen? I'm not seeing her.
Yes, good morning. I'm here.
Oh, hi. Good morning. How are you?
I am well, thank you. Thanks for having me this morning.
Thank you so much for taking the time. Lots of celebration, if you will, but certainly a lot of chatter around this case against Meta and YouTube, TikTok, and Snapchat. Give us a background to this. Tell us about the case. What was this all about? Who were involved?
Absolutely.
Yes.
So it's considered what we call a bellwether case. It was a test case. And as you say, it's probably going to open the floodgates. But so basically you have a young lady who filed an action in 2022 alleging that these platforms were addictive and that they caused her harm. Now, while the case was filed in 2022, there were several cases filed at the same time. And we consider this a bellwether because I guess all the conditions around this one was right to test what I think was a novel theory by the plaintiff. So it has a long history, 2022 verdict in 2026. So there was a lot of things that occurred between 2022 and now. Particularly, Meta and Google tried to get the case dismissed, basically saying that there was no case here. There was no cause of action. That it was properly rooted in the third-party content that the individual was viewing, and not them, not to their what of their doing. But the novelty of this is that the plaintiff's argument wasn't about third-party content. The plaintiff's argument was about the design of the platforms. Particularly, their allegation was that the design of the platform was negligent. Having the infinite scroll ability, autoplay, and these algorithm feeds that created or curated the content specific to the individual is really what caused the harm. So it wasn't the content itself, it was the design of the platform. So it took it out of the statutory protections that Mega was alleging that they had. They couldn't be held liable for third-party content, and it brought it squarely in what we call products liability matter, meaning it was the product that was the problem, the design of the product. They weren't focusing on the content. And this is what created the uniqueness of this case, and why it was considered a test case, because it was the first time it was a novel argument that they were utilizing, and ultimately proved successful. So after the case was filed, as I stated, Mega tried to get it kicked out by doing what's called a motion to dismiss. And they were saying they were protected by the statutory guidelines. In fact, there is the statute that they were referring to is called Section 230, which basically says that, they're shielded from any liability for user content. They also tried to raise an argument about their First Amendment right to have curated content, and it would impact or affect their ability to choose and organize how they curate their content. So they really tried to get it kicked out on those grounds. But the courts found that the design argument was valid, and that they accepted the plaintiff's argument that the design alleged flaws, well, no longer alleged, they're finding that they were flaws, were in fact valid, and that the features, including the algorithm and the infinite scrolling, the autoplay, could actually cause liability. So they weren't able to avoid the action, they were forced to move forward. They subsequently went on to file, there was discovery. In a litigation, you have discovery where they exchange information. The plaintiff is allowed to ask for documents. The defendant can ask for documents. And I think one thing that really propelled this case forward is that prior to the filing, there were documents that were released that alluded to issues with the platform. So when during discovery, of course, they get more information to bolster their arguments. And after discovery, Meta again tried to get the case ended by filing motions for a summary judgment, or there's a method called summary adjudication that they can do in California, meaning they wanted to get a ruling on certain aspects of the case, and they also failed at that, which is why the case went to trial. At trial, the juries had to sift through a lot of information, including academic or scholastic articles on the issue of social harm to teens, because it's a concern, which is why you have the floodgates of these lawsuits. Yes. These teenagers, I don't know about you, I remember having an event at my home where you looked and you saw all of the teenagers sitting together, and instead of engaging with each other, they're all on their phones, right? So it's a real issue faced in the schools, in your homes, where these young folks are so tied to their devices and social media. So there's been a lot of studies on it. And the jury had to shift through competing arguments. There's some studies that said they are harmful to children, teenagers, and there are others that say they're not, But they had to really go through all of this. You also had competing arguments from, my apologies, I'm sorry.
No, I'm thinking, and this is why we hear this comparison to the tobacco industry, which I'm wondering about. But I suppose we'll get to that with the competing arguments, acknowledgement, if you will. But it's an interesting thing because this was a civil case, and Meta has said that they will appeal. What does that mean? And it's I'm just moving it because in the interest of time, thank you so much for kind of laying that foundation for us so we understand better what has happened. YouTube, I suppose, also has its own response to this. What do you know in terms of what will happen on the backside of this? Have we heard anything else from Meta or YouTube if they will appeal? And what does it mean, set a precedence, if this is a civil case and not one that's going through another type of court?
So an appeal means that they are going to go to the higher court. So this was in the so there are levels of courts. You have the court of first impression, and you have an appellate division, then you have the United States Supreme Court. So they're going to go to the appellate court to try to have the decision reversed. So they're basically, for you to appeal, you have to argue that the courts overlooked some key facts. So it'll be interesting to see what they come with to try to convince the court that the appellate division that the lower court got it wrong. Yeah. They'd really have to go back, parse through any rulings that may have occurred. You know, as a litigator, one thing you want to do is what we call preserve the record. So you want to ensure that everything, any rulings that was made during the trial was captured, and they got, you know, probably going over everything to see what would be appealable, what they could take to the appellate division to say, hey, the jury got it wrong in this instance, and we need you to take a look at this again. And they're doing this because, as you rightfully identified, it has now opened a lot of opportunity for other litigants in the same space. The day before this decision or this jury verdict, there was another verdict in Texas that was brought by the state of Texas, and that was a $375 million verdict. So again, having these losses is going to definitely encourage other litigants to move forward with their case under the same theory that it was a design flaw for these platforms and not necessarily the content.
Karen, help me to understand this, because it's reminding me of the glyphosate cases, where we all know glyphosate is in Roundup. We all know the studies are out there saying it causes cancer. There are massive cases. And a lot of payout, billions of dollars of payout over time. But at the same time, just last week, we saw the president, or 2 weeks ago, of the United States signing an executive order. Glyphosate, in a sentence, is too big to fail. It's a national security product, even though it is so harmful. As opposed to tobacco, which is, it's a whole other thing. Vaping is still, tobacco just slaps something on and says it causes cancer, and everybody, people are still smoking, people are still buying. Do you think that we're in that moment where, because they're all using social media anyway, I'm talking about government, academia, military, the whole works, Wall Street was too big to fail, that the optimism that people seem to have in terms of how the litigation is going, how the law is dealing with this, that this might be a little bit premature?
Not necessarily. I think there can be some retroactive steps that they probably will take, because one thing that came out was a failure to warn. Now, if you've warned folks about the effects of what's, or the risks, and people assume those risks, then they're not liable. So in this instance, and I think in a lot of the these larger cases, if you fail to warn, if you know, and I think a lot of this hinges on what they knew, because there's documentary evidence that they knew of the potential harms, they knew of the risks to the public, and they ignored that. Why? Because of the economic benefits. They're making money, and they're just focused on the bottom line. So they didn't want to reveal these risks or reveal these pitfalls that could affect those bottom line. And I guess this is where we go to, these industries are too big to fail because of the economic value that they have. But to the extent that you are aware of these risks and pitfalls, if you have these big, large letters or words saying, this is what could happen if you do this, then, if the consumer chooses to continue with that product, then they've assumed the risk, and you can no longer, takes it out of that litigation realm. So, the cases that already exist may go forward, but if these platforms going, for the future, put these warnings up front, very visible, because one of the aspects of this case was that they were arguing that neither the mother or the alleged victim read their terms of use. And the plaintiff's argument was, well, if there's something this important, it can't be buried in the term of use. It has to be upfront, bold, very readily apparent, so it could be seen and not, you didn't have to go parsing for it. So in these other cases, to the extent that they know Roundup causing cancer, I think now you're seeing advertisements about these, and the bottom of the screen you'll see may cause cancer, or allegations of use could cause cancer. You're seeing these disclaimers when they're doing these advertisements.
I'm so concerned, Karen. It's because oh goodness, my own father was poisoned by Roundup. Not just causes cancer, it causes dementia, Alzheimer's, and all that. And the most we get is a warning. But if the country to which these, for example, Jamaica as a nation, has said to us, with all of the protests, the marches that we've had over time, they have said to us that nothing's wrong with it. And then we have the U.S. president signing an executive order saying that it is a matter of national security, and so the production will continue, and it will continue to be available. The too big to fail, like Wall Street, like glyphosate, like the COVID vaccine, if you will, at the time. Now we're getting a whole different, I suppose we're going to see a whole lot of lawsuits coming out of that, or regardless of the 230-like kind of issues around that. And I'm going to take a break. I want to come back and pick up from there to say, what does this mean in the bigger scheme of things? We expect so much from MySpace. I don't know your age, Karen, but you look pretty young to me. I don't know if you remember MySpace, Flickr. You remember Flickr?
Absolutely, yes, I do.
High five. I mean, we were warning from them days, and here we are now. But for those of us who have been warning from them days to these days, we're saying to ourselves, this is good, but this is not it. But let me take a break. I'll come right back, and I'm going to step away for a minute. Give me a minute. I'll take a break.
Sagicor Investments, leading the way to wealth as the #1 dealer in value traded on the Jamaica Stock Exchange. The time by Sagicor Investments is
now 18 after 8 o'clock.
Touchdown in the island. Though, is it a new one? This a container massive. All parts inclusive. Yo, them are body parts, engine, suspension, interior, accessories. Everything you're gonna need if you carry no that is here for. That be running pan that before them done. New container arrived. Massive auto parts and car sales. 158 Main Street, Pineapple Place, Ocho Rios. Call us now. 876-298-6413. 876-974-7197 or WhatsApp 561-1223. Massive auto parts and car sales.
Power in great moments. If you have financial needs, Chris and Charles will fix them for you. Power in great moments since 1992. Oh, we have it all. Power in great moments. relax, you got Chris and Charles. Oh, we have it all. When you think alone, think Chris and Charles.
G, you know say Mikey no come?
Hold on.
No, sir. That sound like consumption.
What that?
Tuberculosis, aka TB.
Now all time something like that. After nobody not get that again.
I saw you think TB still the boat.
If you have a cough for more than 2 weeks with fever, night sweats, and weight loss, go to your doctor or health center and get tested now. Let's be vigilant and stop the spread of TB infections. A message from the Ministry of Health and Wellness.
Like clockwork, it's that time of the year again as the prestigious Penrelay Carnival welcomes the Jamaican High School Juggernaut from April 23 to 26 at the Franklin Field Stadium in Philadelphia. The likes of Kingston College, Calabar, Jamaica College, Excelsior, Erin Allen, Heidel, and Homewood will lead a large Jamaican contingent as they all battle to bring back the famous wagon wheel, one of the most iconic trophy in the sport of track and field. The Sporting Choice Irie FM will once again be in the city of brotherly love, providing live and recorded reports from the event. Coverage of the Penrelay Carnival on Irie FM comes to you courtesy of Massive Auto Parts and Car Sales, Pineapple Ocheria St. Anne. For the best in auto parts and car sales, call Massive, we've got you covered.
Skymar Building Supplies and Hardware, Highgate St. Mary, open every day including Sundays and public holidays. Call Skymar 876-724-1890. Falmouth Chicken, looking for scrumptious food? Falmouth Chicken is simply the best in Western Jamaica. Vibes, pizza, wow!
That's coverage of the 130th running of the Penrelay Carnival from Philadelphia between April 23 and 26 on the People Station, Irie FM.
Irie FM. Akipod Restaurant and Bar in association with Raw Souls Family present For the Wayne's All Black Birthday Celebration Sunday, March 29 at Akipod Restaurant and Bar, 61 King Street, Linstead, St. Catherine. Music by DJ Lollipop from Irie FM, Luke and Silver from Metro Media, and Job Loss. Must be 18 or older to drink. Drink responsibly. ID required. I tell you something, this is not a normal celebration. It's a general earth strong. One father win, any other win, I must wonder.
This Good Friday, April 3, Beltron Kite Festival takes over Reynolds Sports Complex in Golden Grove, St. Anne. Performances by Skipper, Da Vinci, Professor Nuts, Rally Banks and Top Banks, Dancing Dynamite, Jamaican Michael Jackson, and many more. Kids 12 and under free. Lots of entertainment for the family. Countless rides for the kids. Free shuttle from Fiscal Gas Station, Golden Grove. Tickets, adults 4,000 pre-sold, 5,000 a gate. Children 13 to 18, $1,500 pre-sold, 2,000 a gate. Sponsored by Ford, Dolphin Cove, Mystic Mountain, Beltron Hardware and Construction, Beltron Enterprise, JSJ Logistics, and etc. See you there.
Yeah, look how you're pretty on my phone screen.
All right, we're back with you inside of the Africa Forum. This is Running Africa, and my very special guest online is Karen N. Wilson Robinson, attorney at law, and she's been watching very, very closely the social media litigation, the cases that are unfolding in the United States. And obviously, Karen, we've seen decision being taken in Australia regarding age of use, and we have also seen discussions underway in the United Kingdom. So this is something that's it is burgeoning, it is blossoming. People are talking about this, and there are lots of cases pending. But with just about 3 or 4 minutes to go, I'm going to give you the time to talk about what does this mean in the wider scheme of things. And please remember to talk to us about whether or not this is a precedented case, if this sets a precedent, considering that it was a civil case, and when does it really become precedent setting?
So it is precedent because it's the first of its kind. And while it was in California, other states can cite to it because it's the only one of its kind. So here in the United States, that's what makes it precedent. Going to the appellate division, if the appellate court now, let me take a step back. It would be persuasive for the other states in that the courts and judges in the other states can choose to follow the decisioning there. Mm-hmm. Going to the appellate division, if the ruling holds in appellate division, then that's when it carries a lot more weight because you have an appellate court that says, yes, we agree to this. So if it holds up there, then you have the issue of how far does the liability go? You know, is it going to is going to be higher damages awarded, etc. And if upheld, it could force these platforms to redesign their apps. You know, maybe limit the addictive features. You know, make sure that there are more visible warnings for the platforms. And it's eye-opening because now it has raised the awareness here in the United States that these platforms have to really now take some action. They can't simply hide behind the third-party content protections that they've had. They really now have to be mindful that you know, this decision is there, and it could have far-reaching implication across the board. Now, one thing I think we didn't mention is that both TikTok and Snapchat were in this action, and they settled before going to trial. You know, once that decisioning on the motion to dismiss and the motions for summary judgment were made, and they realized that the court was open to the novel idea that is the design flaw and not the third-party content, they decided to settle in advance, so they did not go to trial. So there's no verdict as against them. However, I think that would have prompted them, you know, and I don't work for any of these entities, but it would prompt them to take some step to ensure that they are putting in these safeguards for children. Now, on the flip side, we could argue, well, where are the parents? You know, where are the parents of these children? You know, if a child is sitting on their phone for 4, 5, 6 hours straight, where are the parents? And that was raised. But at the end of the day, it still comes down to what they're saying. These apps have to put in safeguards.
Because I do talk about design. They went for the product, not for the content.
Absolutely.
And this makes it, and I suppose it's hard to argue parental supervision when you're already saying this is as addictive as cocaine because of how you have designed this product.
Absolutely.
Does TikTok and Snapchat, does it become moot if this goes further, for example, and they lose Meta and YouTube, if they go to appeal and lose, does it become moot for those who have settled?
No, they settled, meaning that they decided it wasn't, it didn't make sense for them to continue fighting. So I don't know what those settlement agreements were. I haven't had access to them.
Yes.
I don't know if they're public, but it means they're out of the case altogether, and it's just Meta and Google that are taking it further.
What about Congress? To make something really happen, does it have to be a decision by Congress as opposed to or in tandem with what's happening through the courts? And I have a minute, sorry.
Sure. It could be codified in law if it gets to that state, because then that it would. But again, these are corporate entities, and you really don't have legislation that's going to control how they conduct business, because that would have a stifling effect on businesses, correct? Right? So it really comes down to whether there will be some statutory guidelines similar to the protections they have under Section 230 for third-party content. But if it's a design, I don't think that it would be codified in any kind of legislation, because you're going to be stifling innovation. You're going to be stifling anyone's ability to create some gadget or invention that's supposed to be revolutionary, right? So I don't think it would get to that congressional level. I think it has to come down to their policies within the corporations, the policies and protections that they'll implement to ensure that they don't find themselves in a litigation regarding their policies and their designs.
Exactly. And then at the same time, we haven't even factored in AI into all of this and where it's going. We look over at XAI is doing a whole other thing, a WeChat situation, because if you go at the WeChat as we have in China, that's a whole different design. And I don't even know the extent to which it falls into the ruling that we had there from the court, the finding from the jury. It's fascinating how this is unfolding and what is likely to happen.
And isn't that what technology is all about?
Yeah.
You know, it is wonderful because it's designed to make our lives easier. But on the flip side, it poses these pitfalls and these risks. So how do you weigh the risk? How do you balance the risk and the rewards of technology?
Karen, I'm so happy to have had you on. Thank you so much. I look forward to our continuing networking and relationship inside of this program from time to time. Thank you so much, my sister, for taking the time and for helping us to understand this ruling.
Thank you for having me. Have a wonderful day.
You too, you too. And I know you're in time for church, so there you go.
Yes. Thank you.